Welcome to Red, White, and Blue. I apologize, I'm a little hoarse this week, but I'll do my best. This week, well, I'm Gary Polland.
I'm Barbara Radnofsky.
And this week on Red, White, and Blue, we're going to talk about criminal justice reform in Harris County and in Texas. And we have three really good guests who are going to be able to give us insight. And the interesting thing about this topic, Barbara, is what? That the parties, that is the partisan divide that we have in Washington, maybe in Austin on a lot of issues. On this issue, there's actually a coming together by the side.
There's tremendous coming together, and I'm very interested to hear across party lines, there's clearly commonality in some of the problems we need to solve.
We have great resources this week. We have Kelli Johnson, who's judge of Harris County Criminal Court.
Thank you for having me.
178th, got elected 2 years ago and is well respected, a great judge. We have Tom Berg, who's the first assistant Harris County District Attorney, a very important job, Tom, I might add, who's no longer a gypsy, actually has an office now after the flooding, because he was one of the Harvey victims. We have Derek Cohen, who's from Director of Right on Crime, which is a huge player around the nation in terms of reforming criminal justice. Normally comes from the conservative side.
Yes, sir.
So three great guests. So you want to go with the first question?
Well, I would. Why don't we talk about the Harris County Courthouse if we get specific? There's a couple of issues that are infrastructure as well as personnel issues. Court sharing and do we need a new courthouse?
Well, I can say that we judges have turned into summer camp. And it has been a great cooperative effort, but as I tell the public that are now coming in to various courthouses, and our courtrooms are switching all around, like hopscotch, the criminal justice system has suffered the worst. There's absolutely no doubt about it. The inmates who are pretrial detainees waiting for that trial, trying to get their time in court, they have been suffering the most. And I'll say the civil judges in the DA's office, they have been great about handling. Every judge has a different court docket. They have different days, they have different times. And so that's been really, really tough to get courtrooms.
How do you follow that, Tom?
Well, we've had to be exceedingly flexible under the most difficult of circumstances. We spent almost 11 months homeless. We were scattered through 11 different buildings around the county.
Unbelievable.
And we've only recently come back, for most of us, into one building, which is still more than a mile away from the courthouse. We have to take a shuttle bus to get down there. But it's better than what we had before because at least the people are together. And we have more of a sense of unity, a sense of teamwork.
Has the results of Harvey slowed down the ability of your office to close files?
I don't think it has. Of course, intake remained open through the storm. We still operated 24/7. So we continued to take cases as they came in. For a while, we couldn't get to trial, but nobody could get to trial. It was just the crisis of the storm. But once trials resumed and the cases started moving again, our people got going again. And they've really done a stellar job of adapting to extraordinary circumstances. And we've got to acknowledge we are still in that Harvey crisis mode.
Not away. And Derek, of course, you're a leader in criminal justice reform. Is Texas over-criminalized?
Simply, yes. If you look at the crisis that was foisted upon, like the Harris County infrastructure, some of these issues are not things that need to be adjudicated in court. Those things that are handled in cumbersome ways. And I think that having a general eye towards resolving a lot of the over-criminalization problem, as is going on in many facets here in Harris County, would help alleviate some of that strain, especially if there were to be a crisis like that again.
Well, your group is a significant advisor to the powers that be in Austin. So are you going to give them advice in terms of cleaning up the penal code, getting rid of crimes we really don't need to be crimes anymore?
Exactly. We've been working on the issue of over-criminalization itself for quite some time. You know, perhaps you've heard the story from Mark Levin about the 13 to 16 oyster harvesting felonies that exist in Texas law. Things like that, things that actually are loaded guns that we leave around in our actual penal code, are things that tend to be over-criminalized. You know, over-criminalization really came to its ascension in 2015 in the U.S. v. Yates decision. In U.S. v. Yates, an individual was prosecuted under Sarbanes-Oxley for throwing undersized fish over the rail of his boat. He was prosecuted under the document destruction provision of Sarbanes-Oxley because that was the shredding provision for apparently throwing fish overboard. And so that generally shows how you have mission creep. Obviously, if he's caught grouper that does not belong in the live water tanks of a fishing boat, they should not be there. It might even necessitate a punishment. But should we use a dense financial penalty in order to punish that? That's simply not what our criminal justice system is for.
Go ahead.
What are some examples, other than fish, what are some examples for Texas, and especially for Harris County? Marijuana, I've heard about.
Well, I can definitely take an aside from all the sea life-related felonies, but marijuana is a little more of a complex one. But things that are generally in the penal code or outside of the penal code that have an analog, say, in the civil system, or something that shouldn't be penalized at all. One of the third-degree felonies that you can get here in the state is for defaming the financial health of a credit union. So basically, if I were to say so-and-so federal credit union, doesn't have enough money on the books to cover a run on itself, that in and of itself would be a third-degree felony. And so having that in the code is just another thing that can actually be brought to bear in a prosecution, could be used as a coercive plea, whatever the case may be. Now, you brought up marijuana. Now, marijuana is a I would say, divisive issue in Texas, but we see a lot of movement across the board on that. The Republican Party of Texas, in its platform, actually supported civil penalties. In the debate with the governor, in his debate last week, I believe, supported a transition from the Class B misdemeanor it is now to a Class C misdemeanor. So basically taking a processing, one where you have to take someone in, book them, offense to something that can be handled much like a traffic ticket. And that would have massive implications for specifically Harris County on the pretrial population in the Harris County Jail.
Well, that would be good. Tom?
Well, when we came into office, when Kim Ogg came into office, one of her promises was to address this issue of overcriminalization. And we started with the marijuana policy, which basically allows a person, if that person is caught, to take an online class on using better judgment, and then the case is simply dismissed. So we don't, and the objective is not even to bring those people into the criminal justice system, not to bring them to jail, not to bring them to court, but to dispose of it administratively and efficiently and cheaply, so that people don't get these criminal records with the horrible consequences that sometimes accompany a conviction for just possessing marijuana, especially for young people. And by and large, that has worked. I think we probably laid the groundwork for Governor Abbott to now get down to a Class C misdemeanor. We think we'll probably go lower than that, and just decriminalize it completely, because there's popular support for that in Texas and around the nation for taking that part out of the mix of criminal justice.
And what remains with these, let's say, defamation or for harmful conduct to others, if it is, we still have the civil system. Correct. And I think that's what you're explaining.
Yes, ma'am, with an ostensibly easier burden to prove in such a case.
Interesting you talk about civil system, criminal system. Attorney General Paxton has faced that dilemma for a number of years, because he had a civil complaint filed against him regarding to securities, selling securities without a license, ended up paying a fine, but there's a criminal law on the books that he's being prosecuted for.
Of course, it's a criminal.
Would wish we didn't overcriminalize there.
It's a criminal law. He's got 3 violations, and the criminal law that he violated was one he voted for as a member of the legislature. So you can't say he didn't know about it.
No, I will tell you he didn't, because when he
How
came
can
to
you
meet,
not know about
he
you
came to
voted
meet
for it?
with me, and I had to visit with him.
Yes.
And I said the ultimate irony, because we've talked about overcriminalization, we talk about criminalizing all kinds of conduct that shouldn't be criminalized, and I said, here we are. You voted for this. No, I knew it. So you voted for this bill to criminalize it. In hindsight, don't you think that was a big mistake? He said yes. We overcriminalized.
Someday we'll talk about that, because these issues of what is behavior that can harm the public who is deceived by somebody misrepresenting themselves is sometimes going to put high officials in prison, or at least to trial, but that's not really what always happens. And so maybe we could talk about what happens across racial lines.
I was going to follow up with Tom and with Judge Johnson on the issue. Have you all have an organized way, you being with your judicial colleagues, you with your DA colleagues around the state, have you all started going through and looking at the penal code and coming up with ideas of things like, why is this a crime, why is this a crime, we don't want to waste time prosecuting, stuff like that? Is anything like that going on?
We review constantly what we're pursuing and what we choose not to pursue. We have the discretion on what we accept from the officers when they make an arrest. For example, welfare fraud. We're about to get completely out of that business. That can be handled administratively. Generally, that's a prosecution of poor people who don't have money and trying to get something where there is nothing to get. It is not an existential threat to our society, and we don't think it belongs in criminal court when we've got serious violent crimes that we need to attend to. So in the reallocation of resources, especially post-Harvey, but even before, there are a number of those kinds of crimes that we will not pursue.
I want to ask you, Judge, this question. You deal obviously with people every day. They go into the system. They're going to go on probation or they get sent to prison. Do we have enough options and alternatives for you as a judge to use to place people where they need to be so hopefully they don't return?
Oh, wow. What a interesting question. That's a loaded question. I can tell you that what we're doing is not working generally. I mean, we have the highest incarceration in our country than any other country per capita. But, and I talked to Barbara about this a little bit the other day, you know, I think we have some great things that are starting. I really do. And I think that there are some courts and some judges, I think in the past, and I've been in criminal justice for about 20 years, that they'll have cookie cutter policies. And the problem is human beings are not cookies. So you can't have a blanket policy for a crime or an offense because everybody's different. So I think as judges, we have to step back and take a more thoughtful view of criminal justice. And, you know, what I see, the legislature created state jail felonies back in 92 to 94 to take low-level offenders to an area to kind of get them out of the hard and fast prison. Well, the problem is those level offenders, there's starting to be more racial and ethnic disparity there. 60% of state jail felons, that's our fourth degree, in case anybody doesn't know what that is, out of the degrees in felony. The people that are pretrial detainees in state jail, they are more likely to take time over community supervision, more thoughtful ways to give them structure, encouragement, boundaries, empowerment, which I know sounds weird coming from a felony judge, but sometimes I'm the only person that's ever told that person, you and I have skin in the game. I know that you can do it. I know that you can succeed. I'm going to check in on you. I want you to write an essay and come back and deliver it to the whole crowd and see if you can learn from what you did and affect other people. Because no one's, some of these folks that can't afford to get out on bond, as judges, and it's, brings up, I'm sure, some other topics we'll talk about, but we now have tools based on criminal justice reform and foundations that have put their money into helping us do studies, get data, to develop more thoughtful ways to help people.
To follow up on the ability to distinguish better about who's a risk and who's not a risk, I want to ask you about personal recognizance bonds.
All right.
Good question.
And these are people who don't get qualified for a higher bond, and so they don't get the pretrial assistance that the higher level of bonds people get. Am I right?
Well, right.
Explain it in English.
Okay, so it used to be the school of thought. You didn't see many, I call it PR bonds, just to kind of shorten it up.
Personal recognizance?
Personal recognizance bonds. This risk assessment tool that I talked about, it's a pre-screening assessment tool that we have that looks at basically a person's background, looks at their risk of returning to court, and looks at their risk of safety on the community. So they look into, has this person been charged before and did they appear like they're supposed to? Have they committed any violent offenses in the past? And then there's a ranking. Now, it's not an end-all be-all, as I said earlier. It is only a tool that can be used to see if this person with responsibility can be, pretrial actually sends them a text to let them know what time to be at court. They don't have to secure their bond with any money, and they're trusted to come to court like they're supposed to and not penalized by not having enough money.
And my question is, to those people who aren't deemed to be of that caliber of ability to return, don't they need the pretrial assistance even more so than the people who get the higher level of help?
Yes.
And so why don't you make more people at that level as long as they're not a huge risk to society. If their problem is they just lack the ability to get to the courthouse, they need that direction, they may not have a cell phone, that somebody can text them to. All of those factors seem to me, if you want people not to violate their conditions of not returning, help them get to the courthouse.
Well, and that's certainly what I think they're trying to do. Pretrial services, I'm the chair of that committee, and there's different levels of risk that we place on where someone falls. And then maybe the court might want to put, all right, I'm willing to take a risk on this person to give them a chance, but I'm going to help them along the way and make them have some conditions on their bond to sort of keep them on track, keep them cognizant that they have court, that it's a big responsibility. But let's say, for example, a low-level drug possession. Let's say they get a PR bond. Well, what is the likelihood person caught with a controlled substance may actually use a controlled substance while on bond? Pretty high, right? If they have a drug addiction of some kind. Well, instead of revoking their bond and throwing them in jail, why don't you require them to go to the Houston Recovery Center and actually do an active working on their problem?
Start.
So start.
And do you have authority to do that now?
Yes.
And I guess you do it.
Yes, because I think that's a lot better than throwing them in jail and then let them sit there.
And rot.
And lose their job and lose their family.
Their
and
car, their
probably
belongings, everything.
Yes. And I tell them, and I talked a young woman out of a time today, and I said, I'm not going to accept this plea. And I said, you understand, by you taking time served on a felony, you can't go buy a car, you can't go rent an apartment, you can't get a good job if you want to go back for your education, you're probably not going to get in the college that you want to go.
Voting.
You can't vote. And I said, what were the goals you had when you were little? And so you got to get them out of their current situation and think about the big picture. And I think that's what we're all trying to do here.
Tom, I want to ask you, bail bond reform has been a big issue, and we'll get to Derek's take on that too. And we had a federal judge impose rules on our county court judges. I was going to ask you, how's that working for you?
We're fine with it. We're not one of the litigants, so we've been able to be informed bystanders and
what
occasionally
what I mean by how's it working? Are the people that are now getting released, are they overwhelming numbers showing up, or we have a problem with that? Does it cause problems where you guys and gals cannot take care of your cases because the defendants don't show up?
We don't have a significant problem with failures to appear slowing us down in the processing of the serious cases. What we need, and we've talked about the risk assessment tool, and it's flawed because it's tied into the cash bond system. It's used as a predictor for how much of a cash bond should be set, which was not the intention of the Arthur Foundation when they created their tool. And the only place it's used with a linkage to bail bonds is here in Harris County, Texas, not anywhere else in the country. So there are issues with that we could take hours to talk about. But what we need that we do not have is a pretrial service agency that has sufficient personnel to actually work with the number of people who need the intensive supervision. You can compare it to what is done in the federal side, for example, where they've got a dedicated agency for that purpose within their probation office. Here, they're understaffed. They don't actually conduct individual interviews for most of the defendants for whom they make recommendations. They gather some data at the time of arrest. They create a number based on the information that they've got, and they use that as a predictive score to set normally what is a cash amount and then a recommendation of whether it looks like it might be a good risk for an unsecured bond.
So what you're saying is you don't have the backup like you do in juvenile court, for example, where when children are released, they can be released on one of 2 or 3 different programs that include supervision, could include counseling in the home, could include treatment for illegal drug issues, etc.
That is a good comparison because the juvenile system is set up the right way in terms of how do you intensively supervise these people to make sure that they make progress and they make their appearances. That's not how it works on the adult level.
In fact, I got a young man released today on unauthorized use of a motor vehicle, and his mother showed up. He had been released before, had some issues, but he'd been behaving in detention, so we went back in front of the judge. Judge released him, but he released him on what's called PAT supervision, so they supervise, and with a leg monitor, and with an order that he doesn't leave the house without permission of his PAT supervisor.
So can we do it in Harris County? I mean, can we change and reform and stop doing it that way and get more system? Or is it just too expensive?
Well, I don't think it's kind of pay now or pay later type of too
So we should
expensive.
do it.
We should do it. It will take political will. Commissioner's Court obviously has to fund it. They've got to make those hard political choices. But yes, we should do it.
So are they right, Derek, that if we had a more aggressive pretrial supervision agency, that we'd have more success with people, keeping them out of the jail and the prison system, which we know is ridiculously expensive? Is that your experience in being the expert in this field around the nation?
I'd say yes and no. I wouldn't say it would necessarily be incumbent upon the expansion of pretrial services, though, as both the judge and the first DA have identified that's a need here in Harris County, and that is not to minimize this. But I think if we look at the status quo system, one of the things that is neglected from this is, yes, we are holding people who are not of means for too long, people who pose no threat to society. I want to put on the other side of the coin there. We are allowing people to buy their way out who are palpable threats to society. We had the instance last Thanksgiving where the DPS trooper was slain because a person was let out on what I would consider to be inadequate bond, because we have this completely risk agnostic system for doing it. And Tom does bring up some points about it being an imperfect risk assessment, but it is still leaps and bounds better than what's going on in a lot of places across the state, agnostic of pretrial supervision. And so once we have a better understanding of the risk constellation of the individual that the judge is making the determination of, every policy proposal I've seen has simply been one that says, it informs the judge. It doesn't tie their hands. We've had that the bail bond reform that went through in California, and I would be the first to say, Texas is not known for emulating California in many ways, and hopefully with the bail bonds we continue that streak. But what it does do is it moves it towards a more risk-sensitive system, and I think across the state that is going to be a net gain. But in Harris County, especially with the unique population here, it could be that expansion of pretrial services is something that needs to be part and parcel of that.
Let me put on my hard-ass prosecutor hat on for a minute, because the corollary to bail bond reform or bail reform itself is that courts need to have the authority to detain people who are a risk of flight or a danger to the community. Absolutely. Where conditions cannot address those factors. And we don't have it. It's the Texas Constitution is in the way, and state law, and it will require the legislature to propound the law and get constitutional amendments passed in order for us to be able to do that. Unlike federal law, where you can be detained without bond after a hearing and a finding by the court that you are a risk of flight that can't be addressed by conditions or a danger to the community, in Texas, except in capital cases and a handful of other situations, that does not exist.
So is that a tool you need?
Yes, and that was one of the biggest difficulties we had when we were meeting with the Arnold Foundation on this risk assessment tool. And I was talking with their consultant, and she said, I am finding a barrier here in Texas, because in other states, you have the no bonds, the people that you can hold that are true risk for the community. You can hold them at no bond. Whereas here, I could have someone who's on a capital murder bond, on bond, whereas someone over here on a second-degree felony is in jail because they can't afford it. And you see the disparity there. On capital murder, he's exactly right. Even when, if the state chooses not to seek the death penalty, they're entitled to a bond. And so it really kind of ties judges' hands. The most I can do is put them under house arrest, or really give them a lot of conditions to make them accountable, keep them busy. So we do really have to balance that risk. And that's the tough thing about where the Constitution does tie our hands to a very limited number of circumstances.
It can be $1 billion, but you're owed an amount.
Right.
So are you doing any work in this area?
Certainly, and we did last session as well. We supported Senator Whitmire's SB 1338. We think that that the use of recognizance or unsecured bond is we vastly underuse it, much like we vastly underused community supervision back in 2005, 2007. And I think that we have the wiggle room within the current policy, within the proposed policy, to get to a place that will relieve some of these pressures on the jails. Because if you look at the pretrial population, depending on estimates, anywhere between 70 and 80% of the actual county's holdings are actually people that have not yet been adjudicated. Then they run up against the issue that the judge identified with, are they taking a 1244 and getting time served, and they're still getting hit with the felony, collateral consequences. But at the end of the day, they're right back out on the street. You know, we're not having any opportunity to inflect any rehabilitative programming or
And
anything
nothing
else
happens.
in there. Exactly.
Nothing changes.
And that's a microcosm. The pretrial system's a microcosm of the same problem we have going on in the state jail system. And at the end of the day, we're getting into this habit of short-term warehousing, which we're just setting ourselves up for failure farther on down the line.
And then it costs more money, as you pointed out correctly,
Right.
Tom. We can do it right or do it wrong. You just pay more money.
Down
It's
the
a
road, we will.
revolving door.
We see that in the bail bond litigation. We're spending millions now through the county to defend what is a losing proposition, I think, instead of stopping the bleeding and using that funding to actually get some reform done.
Yeah, the kind of things we've been talking about today.
Exactly.
And they're not partisan. They're not Republican or Democrat. They're not liberal or conservative. They're just, sounds to me like common sense, Barbara.
I agree.
Yes, well, that's good. Well, that's the show this week. So I want to thank you all for coming. Tom Berg, thank you so much. Your insight was great. Derek Cohen, you're doing wonderful work in Austin. Keep it up. And Judge Johnson, a pleasure. Good insight. And Barbara, thank you so much
My
for
pleasure.
being on the show with
My
me this
pleasure.
week. And I'll be back next week on Red, White, and Blue.